Hands up if you said you wanted to be a data processor when you grew up. Hello, and welcome to another TDW Tech Bite. This is another in our continuing series about the coming changes to data privacy law here in Hong Kong. And today we're going to speak about data processors. We're going to cover who are data processors, how are they presently regulated, and what is the change that is coming. So, who are data processors? If you ask the man in the street, they're unlikely to be able to give you a real concrete definition of that. Well, here it is. A data processor is a person who processes data on behalf of another and not for his own purposes. So it's like this. I'm outsourcing something. I give it to you. You only do with that data what I tell you to do, and when you're finished with it, you either give the data back to me or you destroy it. That's what a data processor is. He's not using the data for his own purposes, he's using it for your purpose. So who are these people? Well, here are some common examples of data processors. People like outsourced HR service providers, payroll providers, logistics and shipping service providers. These are, a classic example, one of the more complex examples, is in the digital marketing arena. So if these are data processors, why is it so complicated? Why can't we just say, you are data processors, here are the rules you have to comply with? Well, there's a web of relationships there that's quite difficult to navigate. So if you think about it like this, a data processor could have a sub-processor. They may transfer data to another person who may then start using that data for his own purposes and not as a sub-processor. The person may also start using the data for their own purposes and be a data processor and a data user at the same time. It all gets complicated. And then when you add into that the data processor may not even be in the same place as you are. So you could have a data user in Hong Kong and a data processor somewhere outside Hong Kong. Think of the complexities that are involved in that. So it's not an easy thing to regulate. And this is why it hasn't been regulated too effectively. So here in Hong Kong, this is the position. Changes came in 2012 that had the result of indirect regulation of data processors. What do I mean by indirect regulation? What I mean is that certain obligations were put on data users. Those obligations related to data retention, so that a data user had to ensure by contractual means or otherwise that their data processors only kept data for as long as was necessary in order to conduct the data processing activities in question. And there was another form of indirect regulation which was around data security. So a data user, by contractual means or otherwise, needed to ensure that data processors they used kept the personal data of data subjects secure. So far, so good. But indirect regulation isn't very effective regulation. It meant that the Privacy Commissioner, if it was investigating a breach or a complaint, didn't really have locus standi, standing, in order to be able to make direct inquiries of data processors. Also, there was a gap in that if you had a data processor in Hong Kong, but the data user or controller was outside Hong Kong, then there was a gap in terms of the ability of the Privacy Commissioner to look into that particular situation. Now think of that in the context of cloud service providers and the way that cloud is driving things. There have been gaps in the scope of regulation, and there have been gaps in enforcement. And elsewhere, change has already been brought in. If you were to look in a number of countries, they already have direct regulation, oftentimes combined with an element of indirect regulation of data processors. And if you were to look at the high watermark of that under GDPR, there's a raft of things that data processors also are directly accountable for. So what is the change that's being proposed here in Hong Kong? There are three key instances where direct regulation will be brought in. Firstly, data retention. Data processors will be directly required and accountable to the Privacy Commissioner to ensure that they only hold personal data for as long as is necessary in order to complete data processing activities. This is very likely to drive a requirement for data processors to have a data retention policy, and that, if you remember, is also one of the changes coming through. Secondly, there will be a direct obligation and accountability to the Privacy Commissioner in respect for data processors to keep personal data in their custody, in their care, secure and protected from unauthorized access, use, destruction, loss, or tampering. Those two elements, data retention and data security, those were the two elements that were the subject of indirect regulation in the past. Now the Privacy Commissioner is proposing that that be upgraded so he can look after enforcement and inquiry into those areas directly. And the third area is in the area of mandatory breach reporting. Data processors are going to be directly accountable for reporting data breach and data loss to the Privacy Commissioner. Now, if you look at the proposal for mandatory breach reporting that's currently being proposed, that's a reporting obligation of within 5 business days to the Privacy Commissioner, insofar as data users are concerned. Well, the time frame is going to be at least that amount, insofar as data processors are concerned. So what's the big deal about direct regulation? What's the difference that it might make? What is, if you don't comply, so what? Well, so what? If you don't comply, direct regulation is going to result in the possibility of administrative fines being imposed, because that too is being brought in. And you can expect that data processors will be brought within the remit of the proposed administrative fining powers of the Privacy Commissioner. So that's a lot of change. If you are a data processor, what should you be looking at doing right now? Well, the first thing is to look at the personal data that you are presently holding. Do a data inventory. Work out what you have, how you are using it. Work out what your obligations are in respect of that personal data vis-a-vis the data user that provided it to you. Frame an enhanced privacy framework around that in terms of a privacy policy, a data retention policy, and make sure that you implement that. In respect of the information security requirements and the data security requirements you'll have going forward, well, review your information security position. Introduce enhanced provisions, protections, policies, procedures, implement them. Insofar as reporting obligations are concerned, well, you need to be prepared to be able to give the reports within the time frame required by the Privacy Commissioner. So that means you need your rapid response team ready, not there to be engaged at the time that something bad happens. These are the things that are required right now in order for you to be prepared for this change in the law, and we here at Tanner De Witt are happy to help.